morning, back to us. It is Intan Nadhirah from TV3. The lawyers, Datuk Muhammad Zaid Ibrahim, Liu, Taekwat, and Ruben Matiavanim stated that they would threaten and take legal action against Malaysian Bar President Karen Chia ELIN over a statement that said that they were unprofessional unless they apologize and retract the statement on their conduct in Najib's appeal case in federal court within 3 days. The trio also claimed that the Malaysian Bar stated unprofessional and resorted to unscrupulous activities and ultimately not to practice as an advocate and solicitor, and also stated that they will bring legal profession into disrepute. So on the same day, the local media outlets pick up the press release and release a statement and publish an article about it. On August 26, a letter issued via their law firm Zaid Ibrahim, Suflan, T.H. Liu and partners stated that you knew the Najib case had attracted international media coverage and that your imputation will be disseminated to the international community as well. And on top of the letter of an apology stated and warned the Malaysian Bar statement to not make such statement again. Lastly, on August 23, the federal court unanimously upheld Najib's conviction on all 7 charges, which is abuse of power, criminal breach of trust, and also money laundering, with 12 years imprisonment and a fine of 210 million. That's all from us TV3. Thank you.
Assalamualaikum, we are from Group 4. We'll be discussing about a case under the topic of defamation.
Here is the case summary. The issue of this case is whether the 3 lawyers can sue the Malaysian Bar under defamation. The journal article that we use is Malaysia, the Law on Defamation Relating to Social Media. So everyone uses social media these days, whether it's Facebook, WhatsApp, Instagram or Twitter. Therefore, there are more and more cases of defamatory remarks published on social media platforms. The court must achieve a balance between a person's right to free speech and their right not to be subjected to libel in defamation case. So, how to prove defamation? So there are 3 elements to be satisfied before defamation can be proved. The first one is the words are defamatory and the statement must refer to or identify the person being defamed, and third, the statement must be published to a third party other than the person being defamed. So who we can sue? So under section 114A of the Evidence Act 1950, the following 3 categories of person are presumed to have published a defamatory statement unless the contrary is proved. The first one is a person whose name, photograph or pseudonym appears on any publication depicting himself as the owner, host, administrator, editor or sub-editor, or who in any manner facilitates to publish or republish. The second one is a person who is registered as a subscriber of a network service, and the third one is a person who has in his custody or control any computer on which any publication originates. Because of the presumption created by section 114A, it is not necessary for the party filing the lawsuit to prove who published the defamatory statement. So the example case that we are going to look at is in the case of Tong Kim Chai and Ho Kar Fen in 2018. The High Court held that an email was presumed to have been published by the defendant since it originated from his email address. So Tong's case further held that there was also a presumption of fact that a Facebook post was published by the defendant since it was published using his Facebook account. So alternatively, it is possible to bring an action for a pre-action discovery under Order 24, Rule 7A of the Rules of Court 2012 to discover the identities of the person who posted the defamatory post. So in the case of Kopitiam Asia Pacific Serena Berhad and Modern Outlook 2019, the plaintiff discovered that an article allegedly defaming him was circulating on certain website. So the plaintiff contended that he had insufficient information on those responsible for posting the defamatory article. Hence, he commenced an action against the defendant, who were the administrators of the website, for an order that the defendant disclose all relevant information on the identities of the relevant parties. So in this case, the High Court allowed the plaintiff's pre-action discovery, having been satisfied that the plaintiff's intended action against the person responsible for posting the defamatory article can only be fairly disposed of once the plaintiff obtained the necessary information from the defendants. So how to prove that a defamatory statement was published? Because once the defamatory statement is uploaded online, it is easy to prove that it was published. Because the referred case that we are going to look at is Dato' Seri Anwar bin Ibrahim and Wan Muhammad Azri in 2014, stated that the High Court took judicial notice that the internet is used worldwide. So in this case, the blogger known as Papa Gomo had published a defamatory statement with the intention to discredit Dato' Seri Anwar bin Ibrahim to show that he is an immoral person, not dignified, ineligible to hold public office, not eligible to become political leader, and not fit to be prime minister, and a leader who is not responsible and cannot be trusted. As such, the High Court held that given that defamatory statements were published on the internet and people all over the world can get access to the website, so that shows that there was a wide publication of the defamatory statements. So on the section of republishing a defamatory statement, so a republication of a defamatory statement is also still defamatory, because in the case of YB Haji Khalid bin Abdul Samad and Dato' Aziz in 2012, the High Court quoted Gatli on libel and slander, which states that every republication of a libel is a new libel, and each publisher is answerable for his act to the same extent as if the calumny originated with him. So next is a third-party posting. What is a third-party posting? It is a comment left by a third party on the defamatory statement. For example, comment left on a Facebook post, Instagram post, on a Twitter, and others. Because in the case of GS Realty and Lee Kong Sang on 2018, concerned defamatory statements made by the defendant on his Facebook page. There were also secondary publications which included posting by third parties. The High Court held that the defendant was well aware of the postings made by third party but did nothing to remove them from his Facebook page. The defendant was held liable for the post made by the third parties. So for damages, defamatory statements made on social media are regarded as libel as per the case of Tony Pua, Kiam Wee and Dato' Seri Muhammad Najib in 2018. So what is libel? Libel is actual person. So there is no need to prove the actual damage suffered due to the defamatory statement. So case laws have shown that the court may consider the following factors in assessing the damage. So the first one is the gravity of the allegation, the size and influence of the circulation, the extent and nature of the claimant's reputation, and lastly, the effect of the publication. So as you can see from the case and given all the above cases, it is highly recommended that we use more caution when we post or repost statements on social media to avoid being accused of defamation, because social media is considered as public.
Now we move on to the two Malaysian cases that relate to our problem statement. The first one is Henry Ong Kertsem and Patrick Ong Kim Kok. So the fact of the case starts on 18 February 1994, where the defendant was shot 3 times by an unknown person and he was rushed to the Johor Specialist Hospital for the reason. So it was attended to an emergency basis there. According to the police officer, which is in this case Inspector Chong, he managed to see and speak to the defendant himself in the emergency ward, and he was informed by the defendant that the plaintiff had caused him to be shot. This was denied, however, by the defendant himself. As a result of the same reason, the plaintiff was detained for 4 days and 3 nights for the investigation, and he was then unconditionally released. The plaintiff initiated a prison suit and claimed against the defendant for defamation for slander. As for the judgment, the court has ruled that the defendant owed a duty to himself and to the public at large to report the crime, and in this case to Inspector Chong as soon as possible in order that the perpetrator can be apprehended and brought to justice. It was his privilege to tell Inspector Chong the name of the person whom he suspected may have committed the offence in order to enable the police to start its investigation on a firm footing. Inspector Chong had a corresponding duty also to receive the statement from him. It would be up to the police after due investigation whether or not to arrest the person or persons mentioned by the defendant. The statement could not therefore form the basis of an action in defamation. The court has decided that the plaintiff is in fact merely endeavoring to include in its statement of claim the very words which had already been set out in the written statements of Inspector Chong and the other witnesses which had been served on the defendant. The defendant was not taken by surprise that would prejudice his defense. The amendment would not under circumstances require any change in the direction or strategy of his defense that would require new evidence to be adduced. So, the application is allowed. The second case related is Datuk Seri Muhammad Saleh bin Ismail and another, and Nurul Izzah binti Anwar and another. So, the facts of this case starts in a press conference where the first respondent, which was the first defendant in her capacity as the Vice President of Pakatan Keadilan Rakyat and a Member of Parliament, made certain statements regarding the exposure of alleged misappropriation of funds of the National Feedlot Centre project. And also, Malaysia Kini published the statements made by the first defendant, which was viewed by the public. The appellants, which was also the plaintiffs, contended that the statements alleged that the first appellant had misused government funds for the purpose of acquiring or purchasing 8 condo units at KL Eco City were false, incorrect, and were defamatory of the plaintiffs. The first plaintiff asserted that he had purchased of the 8 of these units using his own personal funds, and the purchase did not involve NF Corp's money or government funds. According also to the plaintiffs, the statements could be understood to mean that A, the first plaintiff was untrustworthy, a criminal, a greedy person who had used his wife's position for monetary gain, used government and or public money for personal monetary gain, and to live a luxury life. B, the first plaintiff, if not for NCOP's money, was actually poor, and that the plaintiffs had conspired to cheat and or misappropriate government or public funds. So at the High Court, the plaintiffs claimed damages for defamation against the defendants. The court, in its judgment, states that the statements, read in their entirety with the rest of the press conference release, any fair-minded person could honestly make such comments on the proved facts. The first defendant was merely inquiring into the subject matter of the complaint, and such statements were comments made in her capacity as the incumbent of Member of Parliament, who had the legal duty to make those comments as they concerned the members of the public at large in general and the members of her constituency in particular. The court, in its judgment, states that the statements, read in their entirety with the rest of the press conference release, any fair-minded person could honestly make such comments on the proved facts. The first defendant was merely inquiring into the subject matter of the complaint, and such statements were comments made in her capacity as the incumbent of Member of Parliament, who had the legal duty to make those comments as they concerned the members of the public at large in general and the members of her constituency in particular.
The first issue is whether the defamatory statement made was actionable per se. Generally, a slander will not be considered as actionable per se. Plaintiff actually has to prove that there exists an actual damages, specifically financial damages, and that it is a direct result of the defendant's words as the outcome of the slander. Unlike libel, slander is quite difficult to prove. However, since the statement produced in our case falls under one of the 5 exceptions, the slander made was actionable per se. The said exception is imputation of unfitness in any office or profession, and this element is governed by Section 5 of the Defamation Act. It is stated in the Act that it is unnecessary to prove damages in an action of slander that was intended to disparage the plaintiff in any office or profession, and the case that we are referring to is the case of John Tan Chor Yong and Lee Chai Tian from the year 1971. So in this case, plaintiff, who was an advocate and solicitor, claimed that the defendant's words to his friends and clients was to the effect that he, as in the plaintiff, was owing him several months of rent, and those words were defamatory as the words were intended to belittle him in his office. So in applying Section 5 of the Defamation Act in favor of the plaintiff, and so holding that the plaintiff's case was actionable per se without proof or moving on to the analysis, in applying the previous case law, the statements produced by the president of the Malaysian Bar was indeed intended to belittle or downgrade the three lawyers, as the Bar's statement suggested that the lawyers' acts were unprofessional and that the lawyers resorted to unscrupulous strategies and were ultimately unfit to practice as advocates and solicitors, and also has brought the legal profession into disrepute. The statements produced were enough evidence to prove that they were defaming, and it would taint the lawyers' reputation and destroy their careers. As a conclusion, the slander was actionable per se, hence fulfilling the first requirement. The second issue would be whether the words were defamatory. So this is actually determined by a test, whereby if the statement contained words that tend to lower the reputation of the plaintiff in the minds of the right-thinking members of the society, so that the plaintiff is avoided, shunned upon, or ridiculed, then it is considered defamatory. So the case that we're referring to is the case of Syed Hussein Ali and Syarikat Pencetakan Utusan Melayu Berhad from the year 1973. So in this case, the plaintiff claimed damages for libel contained in a newspaper published by the first defendant, and of which the first defendant was the editor. And the plaintiff alleged that the words complained of were capable of the following false innuendos, namely that the plaintiff was dishonest, disloyal to the government, a subversive element, an irresponsible politician, an ungrateful person, a supporter of President Sukarno, and also an instigator of unrest in the country. So as for the analysis, in applying the previous case in our scenario, the words in the press statements had the effect of discouraging the lawyers, as they have the tendency to lower the estimation of the plaintiffs in the right mind of the society, hence fulfilling the test. So as a conclusion, the statement was ought to ruin the lawyers' reputations, hence was defamatory. So the third issue would be whether the words were directed to the lawyers. And the case that we're referring to is actually an English case, namely E. Houghton and Company and Jones from the year 1910, whereby in this case, the court held that the defamation was established as those who knew him, as in the plaintiff, understood that the words were referring to him, although that was not intended to be so by the author and publisher of the fiction. As opposed to this case, for the analysis, the three lawyers actually claimed that Chia's media statement that was false and malicious contained statements about their behavior during Najib's appeal in the federal court and was clearly directed to them. They claimed that several paragraphs in Chia's media statement were allegedly made in a reckless manner, disregarding whether the accusations were true. The statements were clearly made towards them, as they were the one who acted for the former Prime Minister in the SRC International Final Appeal. And as the conclusion, the words were definitely referring to the last issue is whether the words were published. Publication here means the communication of words to at least one person other than the person defamed. Publication may be in words and in writing as stated in Section 2 of the Defamation Act. A statement directed to a person in private is not considered as a defamation. It is not published because no one else heard or saw the statement. The statement must reach a third person for it to be considered as published and to be considered as a defamation. So the case that we are referring to is the case of Dow Jones and Gutnick. So in this case, an article published by Dow Jones contains several references made to the respondent, which was Joseph Gutnick, and Gutnick in this case contended that part of the article defamed him and he was actually successful in his claim. And as for the analysis, the statements produced by the Malaysian Bar President was published in a press statement and was read by many, hence fulfilling the requirement whereby the defaming words are ought to be published in order for it to be considered a defamation. And so, as a conclusion, the words were indeed published and there was defamation. So in conclusion, the defamatory statements published by the Malaysian Bar President, which was a slander, had fulfilled all the requirements in order to prove that they were defamatory. Hence, she should be held liable for defamation.